How are you? Well, I hope. And if so, I hope you continue to be well. Because according to DisabledWorld.com, if you do not currently have a disability, you have about a 20% chance of becoming disabled at some time during your working life. These odds are significant, and if worse were to happen to a loved one, a friend, or even yourself, it's a good idea to know what your rights are in the workplace, who enforces these rights, and what the procedure is in filing a charge of disability discrimination with the Equal Employment Opportunity Commission, or the EEOC. The Americans with Disability Act was signed into law in 1990 and was intended to help defend disabled Americans from workplace discrimination. However, Disability in Society stated in a 2007 article, 87% of employers in the USA won battles concerning disability discrimination, and that is a failure of effective action against the disabled. So in 2009, the ADA was amended and better defined terms of disability and added that business owners must comply with reasonable accommodations with disabled Americans under their employ. With these new amendments, employers were still winning a majority of court battles against disabled persons whose disabilities were not visually apparent, such as parents with HIV, parents in remission from cancer, and diabetics. Although self-monitoring, taking medication, and other corrective procedures on the job, usually in secret, became effective treatment strategies that not only helped these disabled people live their lives as normally as possible, it also masked their condition, thus fueling an employer's argument that a person is not regarded as disabled and has a responsibility to perform all aspects of the job without reasonable accommodations. Mark Travis states in the Tennessee Bar Journal that the ADAA became effective January 1st, 2009, and the Equal Employment Opportunity Commission's final regulations became effective May 24th, 2011. The primary purposes of the ADAA are to make it easier for people with disabilities to obtain protection under the law and to provide a broad scope of protection and expansive coverage to the maximum extent permitted by the Act. The primary objective of attention in cases brought under the ADA should be whether covered entities have complied with their obligations and whether discrimination has occurred, not whether an individual's impairment substantially limits a major life activity. Impaired persons armed with this knowledge of reasonable accommodations and better defined terms of disability according to the law could help change a trend of court cases favoring the employer over the disabled. If a person suspects they are being discriminated against based on a disability, there are two crucial factors they must try to overcome. And the first one is to act immediately and file the claim as soon as possible. The second one is keep a written record of all infractions perpetrated by the employer. Some disabled persons resemble a domestic abuse victim in that they might think that the employer has the right to refuse them reasonable accommodation. Or they think, I don't need to take my medications as scheduled or when needed, I can suck it up. What's important is I stay in good graces with my employer so I can be promoted, I can get that raise, or may keep me from being terminated. But the fact is, reasonable accommodation is a right afforded to every disabled person by the ADA. The University of Georgia's Disability Study Program states that there are 54 million disabled Americans, which makes it the largest growing minority. That being said, there is no doubt the EEOC is flooded with intake questionnaires of proposed disability allegations. And before they can formalize a charge, a preliminary investigation has to take place, and that is in itself time-consuming. After which the employment and Senate charge of discrimination and must reply within a given amount of time. At the time the charge is sent to the employee, an EEOC representative contacts the disabled employee for verbal testimony over the phone to get a clearer picture of the charge. From there, it's a waiting game. You wait for the employer to respond, You wait for the EEOC to assign your case to an investigator. This process can take 6 months, a year, or even longer. But once the EEOC finishes their investigations, there are 3 possible outcomes. They say there is no cause, meaning the employee wasn't discriminated against. 2, the EEOC finds cause and issues a right to sue order. 3, the EEOC finds the offensive so heinous that they will represent the employee themselves either in mediation or in court. I think I'm about out of time, so I just want to say stay informed and stay well, and thank you.